for a release of the account and for will deposit the amount. There is no intent. And there is one case, in that case a batch of 3 cases.
One.
Well, in this case, it is
One at a time.
But it is a batch of
Mention tomorrow. One at a time.
Lordships kindly
Yes.
the case outside the list MA 121 of 2020. Today is the date fixed for issuance of because today is the date fixed in this MA 121 of 2020 is outside the list. Today is the date fixed in executing for issuance of warrant for action because
What is your ground?
the ground is the real was not valid.
Yes, sir. Without defects under the refer admission. If without defect.
Lord, may I mention one second appeal?
Second appeal is mentioned on Thursday.
First.
Thursday.
But there is limitation in stay petition.
So limitation and stay is also there. Under the appropriate heading without defects. Wednesday.
So may I restore?
The next Mr. Alok also Wednesday.
Yes. So may I restore admitted second sitting order? In this case, upon admission, the stay has been granted towards petitioner. Now, since the lower court has vacated the interim order in the light of the essence of the servicing judgment order, now the lower court has fixed the next date on 17th of this month to filing the appointment of the Nazim at the cost.
You have filed a petition.
I have filed the locatory application for
You have annexed the order sheets.
of the lower court. Yes,
In lower court order sheet.
lower court.
You have annexed the lower court order by which the stay has been vacated.
Yes, sir.
Second appeal.
Second
Thursday mentioned.
Pardon?
Mentioned on Thursday.
Not the same second appeal.
Second appeal mentioned on Thursday.
Yeah.
May I mention one matter, Your Lordship? MA number 303 of 2019, an IO has been filed for extension of time direction for compliance of the order of amount.
What was the order cost?
There was an order to deposit the entire amount upon BCCL, Your Lordship. If Your Lordship remembers that there was collision of the vehicle and the entire liability was saddled upon the driver. And he was.
So you have not deposited.
Your Lordship, we prepared the check, however, there was delay of few days and the
It was to be deposited where?
here.
Deposited. Tomorrow. Yes.
Under the heading for order, serial number 1, MA number 315 of 50, Mr. Alok for appellant, Mr. Anjali Kumar, Mr. Ikeda for respondent.
But in this case, the paper publication was sought to be made, and I have ascertained from the officers of the insurance company whether the paper publication has been done or not. Update has been quite useful.
One time.
Yes, sir.
4 weeks as paid for by Mr. Alok.
I am for confirmation.
Serial number 2, MA number 334 of 50, Mr. Lakanjan Roy for appellant, Mr. Santosh Kumar for respondent.
The notice was received to the respondent or lordship. We submitted it as but respondent number 1 has not received an respondent number 1 का आंसर रिटर्न हुआ so that
The notice is issued to respondent number 2 and 3 has been validly served. 2, 3 and 4 has been validly served. Good stuff. Fresh notice upon respondent number 1 in its present and correct address, requisite 6 weeks.
And for the filing. A copy. See. Maharaj ji.
By both processes.
Serial number 3, MA number 362 of 50, Mr. Sabir Saki for appellant, Mr. Manoj Kumar number 3, Mr. Rajesh Kala, Mr. Vivek Kumar for respondent.
Yes. लंच में ठीक कर दीजिए. लंच में ठीक कर दीजिए. MBA is adjourned for 6 weeks.
Serial number 4, MA number 371 of 50. Mr. Harit Kumar Singh.
4 weeks time will be granted to this case. We find substitution.
I can't grant you 4 weeks time. As prayed for, this case is adjourned. Statute grants you time. The consequence only I can remediate. I can't grant you time to file a substitution petition.
Serial number 5, MA number 374 of 50. Mr. Alok Lal for appellant. Mr. Kisnayara Jamni, Mr. Rahul Kumar for respondent.
Well, in this case, IA 3255 has been filed for deleting the name of respondent.
IA?
IA 3255 or 22 is filed for
3255.
Yes. And then the limitation application has also been
Just
placed.
a minute, just a minute.
2 IAs are supported on this.
IA 3255 of 2022. This IA has been filed by the appellants, praying therein to delete the name of respondent number 2 from the array of the respondent parties. So, this prayer has been made by the appellants at the behest of the appellants. So since the appellant wants to delete the respondent number 2, this IA is allowed. The name of respondent number 2 be deleted at the risk of the appellants. What is the other?
What is the
the appellant will make necessary correction in the cost item. In reading. What is the other one?
Limitation here.
How many days?
30 days.
30 days.
40.
1-4.
1-4.
Why have you written 30 days?
This. But maybe because of my
There is 14 days delay in filing this appeal. The reasons have been mentioned in paragraph so and so, so and so.
4 onwards.
4 onwards. Considering these reasons, I am satisfied that sufficient cause has been shown to control the delay control.
Serial number 6, MA number 507 of 50. Mr. Abhay Kumar Mishra, Mr. Abdul Tushar for appellant.
As director of copy to serve is point number 4. Copies has to be served to is point number 4. It was served.
You have not filed a substitution petition. Respondent number 3.
And see the previous order was there to serve the copy that I have complied with.
That you have complied, but respondent number 3 is dead most probably.
Then we have to
Check it.
seek instruction and
Mr.
file the
Abhay Mishra prays for some time to seek instructions. 4 weeks.
What will I do?
I people responding to the question.
Serial number 7, MA number 523 of 50. Mr. A.K. Das for appellant. Mr. Arvind Kumar Lal for respondent.
Your Lordship, in this matter, respondent number 6 died, Your Lordship. He had to take the appropriate steps further time.
Counsel for the appellant submit that the respondent number 6 is dead. Earlier time was granted.
Yes, Your Lordship, it was granted on 26/4/2020.
Counsel for the appellant is Kadi. Counsel for the appellant prays for some time to take place for some time. Mr. Clear along. This case is adjourned for 6 weeks.
Serial number 8 with serial number 9 with serial number 10, MA number 540 of 50 with MA number 427 of 50 with MA number 488 of 50. Mr. Rajesh Kumar with Jasmita Manindar for appealing first case.
Possible.
Lordship, I am appearing in serial number 10, that is ME number 488 of 2015. But on the last date, given time for removal of the principal, the same could not be removed, Lordship. But for further 2 weeks time in this matter.
Weeks has not for granted to the applicants. You see very good.
Serial number 11, MA number 567 of 50, Mr. Rajesh Kumar Mahanta.
Lordship, there are 3 applications from the Lordship. The first is Lordship, the limitation in filing the substitution in Lordship. That is 2029 Lordship. Then 2030
of 2022. First of this, IA has been filed to delete the name of respondent number 5 from the area of respondents. What's the next file? This application has been filed by the applicants, and they want, and as they want to delete the name of respondent number 5. So next paragraph. Considering the submission of the applicant, as they themselves want to delete the name of respondent number 5, this IA is allowed. The name of respondent number 5 is deleted at the risk of respondent of the applicants. Yes. Now
2029 is for that limitation if any. So I will give it.
2029 is limitation of IA1.
Yeah.
Who is appearing?
There are several names. Mr. Rajesh Kumar is appearing.
Who was respondent number? Who is respondent number 5 is? No, respondent number. Why did you file 2030 then?
2030 Lordship. On the last date I had tried an IA for substitution. And Lordship said no, file it for me. I mean, since the applicant that respondent had died.
The respondent, there should be a substitution petition.
I had filed it earlier. That is already on.
Then why deleting the name?
Because all that is legal heirs are already
No, already on record.
already a party.
Already parties, already on record.
Yes.
Then why did you file a substitution?
That I paid for withdrawal.
So substitution you have to withdraw.
Yes, substitution and withdrawal.
And the limitation is for
In delaying filing the
substitution. That will also be withdrawn.
that will also.
Because the IA number 10885 of 2018 and 2029 of 2022. Okay, the counsel for the applicant seeks permission to withdraw these 2 IAs on the ground that respondent number 5, the heirs of respondent number 5 is already on record.
Yes.
Is already on record, and there was no necessity to file any substitution application. So they are allowed, IAs withdrawn.
Okay. Lots of
It will come definitely. It will come.
Okay.
India number 12, MA number 571 of 50, Mr. Mohammed Kaisar Alam, Mr. Sanjay Kumar for appellant, Mr. Vijay Kumar for respondent.
Who is appearing?
I'm for OP number 2.
You are for OP number 2.
Yes.
Pass over.
Serial number 30, MA number 583 of 50, Ms. Vandana Bharti, Mr. Nidhi Jha for appellant.
Yes.
Limitation, that's a 90 days limitation.
Use the microphone, please.
Paper limitation, 90 days.
Yes, you are appearing.
Yes, Your Honor, I'm appearing for.
93 days delay.
Yes.
Right.
In this case, I have also filed a cross period, that is numbered 7 of 2020.
Just a minute. Number
7 of 2020. After service of notice within 1 month, I have filed that cross objection.
there is 151 days delay.
90 days. In case MA number 583/15,
Yes.
it's with 90 days delay.
Its office report is 151 days delay. Check it. Counsel to the applicant wants to verify the office notes, the office report. We are allowed this case after 3 weeks.
Along with the cross objection.
Does this case along with
Cross objection 7 of 2020.
cross objection 7 of
2020.
2022? 2022.
Serial number 40, MA number 642 of 60, Mr. DC Goel for appellant, Mr. Pradeep Kumar, Mr. Umesh Kumar Chaubey for respondent.
I for respondent 1.
Where is Mr. Ghosh? Pass over.
Serial number 50, MA number 3 of 70, Mr. Alok Lal for appellant, Mr. Jawad Shah for respondent.
In this case, the IA has been filed for substitution and deletion of the name of the parties on the information supplied by the applicant.
So you are praying for deletion of respondent number 1.
One, and substitution
Substitution of
of,
respondent number 4.
yes,
Here IA number 3336 of 2022. This IA has been filed by the appellant to delete the respondent number 1 from the area of respondent. Full stop. Next one. Since the appellant has filed this application and has prayed to delete the name of respondent number 1, this IA is allowed. At the risk of the appellant, this name of respondent number 1 is struck out. Necessary corrections as well. Now C, flag C. Who is that?
respondent number 4. Let me check the word. Rekha Devi 4.
It is within time.
Minor child Arvind Kumar. Rekha Devi and Arvind Kumar. Rekha Devi is the wife. I have stated in IA.
Who is that? Lakshman Sahu is that?
Lakshman Sahu. Whose wife and minor child.
You are representing whom?
All the respondents, but 1 and 4.
Okay, you will represent the legal heirs of Lakshman Sahu?
Yes.
You have filed wakalatnama?
After substituting.
You have no objection if the substitution is allowed?
No.
Okay, IA number 1. So it has been reported, it has been mentioned in the IA that Lakshman Sahu, respondent number 4 is dead. Full stop. He has left behind Rekha Devi and Arjun Kumar, who is the wife, who is the widow and minor son respectively. Full stop. the applicant submits, also for the applicant submits that the cause of action survives, these two legal error needs to be represented. Full stop. Next file. Counsel who originally appeared on behalf of the respondent number 4 submits that he will appear on behalf of the legal heirs and he has got no objection.
Substituted yes.
Substituted yes, and he has got no objection to the substitution application. Full stop. Considering the submission, IA is allowed. Let name of respondent number 4 be struck off and in his place Rekha Devi and Arjun Kumar so be substituted. Necessary corrections be carried out in writing.
One more idea for information of regarding date of R1 and R2.
R1 is deleted.
One is
दोनों को एक साथ both the IA disposed of.
number 1.
270 of 2022. Both the IA disposed
So
of.
correction to get on by me.
Yes, yes, yes.
Fine. Fine.
Serial number 60, MA number 151 of 70.
In this case, we will have to ascertain the name of heirs or someone of court. We have tried to ascertain one of them. These are the owners.
Mr. Alok Lal prays for 4 weeks. Time period allowed in this case after 4 weeks.
Serial number 70, MA number 466 of 70. Mr. Mr. Dipankar for appellant, Mr. Prince Bihari Sinha for respondent.
Yes.
My application for grant of injunction has been dismissed, my lord. And the impugn order is at page number 90.
No, why is this for orders?
No, there is an IA, my lord,
What?
for amendment, my lord, in the cause title. But we have added parties, my lord, in the suit, original suit. Therefore, we have also made that they must be also.
That IA has been allowed.
Not that IA has been allowed there, my lord.
The suit, the parties have been added.
Yes, they have
That is
been
order.
My lord, the IA, page number 23, starting from page number 23.
Which order you are challenging, represent?
I am challenging the impugn order is at page number 92. May I be allowed to tell the order?
You are the plaintiff or the defendant?
I'm the plaintiff.
What was the nature of injunction you sought for?
But from restraining the defendant to enter take the possession of the land,
Of the?
of the plot.
What the suit was for?
The suit is for my lord's specific performance. Specific performance of the contract. They. Well, initially, my lord, may I brief, my lord?
Where is the print?
The date is the print number 58. Starting with page 58, annexure 7.
Page
58, annexure 7.
Arun Kumar Srivastav, Anil Kumar Upadhyay.
I am the authorized signatory, my lord, of the original printing, my lord, para 2 and 3.
Lot number 186 was allotted to who?
The appellant, the plaintiff.
Anil Kumar Upadhyay.
Yes, no, my lords. It is Viram Dev Chaudhary.
Huh?
Viram Dev Chaudhary.
186 was
Allotted to Viram Dev
Ramdev
Chaudhary.
Chaudhary and 83 Anil Kumar Upadhyay.
Yes.
So who are you?
I'm the appellant, my lords. Viram Dev Chaudhary.
No? You are Arun Kumar Srivastav.
Arun Kumar Srivastav is the authorized agent of Viram Dev Chaudhary.
What do you mean by authorized agent?
My lords,
You
through
cannot be
power,
authorized agent.
through power of attorney, my lords.
Arun Kumar Srivastav has got no locus standi.
My lords, may kindly see page number 59.
Arun Kumar Srivastav cannot have any locus standi.
My lords, may kindly see page 59.
Yes,
Move it, my
59,
lords.
yes.
My lords. Para 1.
Yes.
That the above name Arun Kumar Srivastav.
Where is the concept of authorized agent in a suit?
Well, through power of attorney, my lords, I can file.
You can be an attorney holder. You can be a power of attorney. That means you don't have your independent individual rights. It is the right of Viram Dev Chaudhary. You cannot file a suit in your own name. The suit itself is bad. You have got no locus standi. Was there any privity of contract between you and this Anil Kumar Upadhyay?
No.
Then?
But it is the through power of attorney, my lords.
Power of attorney for what purpose?
For every purpose, my lord, taking the care of the suit also, my lords.
So who has to file the suit? You are the power of attorney. Where is the power of attorney?
But some time will be given, my lords. I will bring that on.
That
Power
means
of
what I
attorney.
could get that this Viramdev Roy Chaudhary has transferred his right by over the property by executing this power of attorney. This is absolutely illegal.
My lords, may I bring that on the power of attorney. Some time will be.
Next week.
Yes. Or 2 weeks.
Next week, at the heading for admission, so your entire suit will go.
Serial number 80, MI number 657 of 70, Mr. DMC.
The Lord of IA is pending in this pending
Yes.
appeal for the condonation of delay.
How many days?
289 days, my Lord. Signed lesion happens.
239.
Right of recovery.
Issue notice to the owner of the vehicle on the limitation matter. Requisites both process 2 weeks.
Lord, earlier the notices was issued to the owner of the vehicle,
What happened?
and substitution service of notice has also been applied by way of paper publication, but he has not turned up till. I have filed supplementary and attended the army law. The publication was also passed.
You are the original applicant.
I am a claimant.
Injury case.
Substituted service has been affected.
No.
Substituted service affected.
No, by way of paper publication, but has been affected by publishing in Daily News at
23 days
Jamshedpur.
delay, na? Delay condoned. Business case of the for admission.
Serial number 90, MN number 418 of 80, Mr. Akalu Banerjee, for other
The question, the RA is pending the option for confirmation of delay. There is a delay of 234 days in option.
Notice ordinary process. The respondents requisites 3 weeks
On question.
on the limitation matter.
Serial number 20, MN number 426 of 80, Mr. DC Jha for appellant, Mr. Abdullah Tiwari, Mr. Abdullah Khan for respondent.
Pass over.
Pass over matter. Serial number 12, MN number 571 of 50, Mr. Mohammad Kaisar Alam.
Yes.
One IN you are doing this.
What?
For delaying continuation of delay.
Continuation of delay, how many days?
163 days.
But respondent number 1 is dead,
Respondent number 1 is the
4 is dead.
owner of the company.
So you have to substitute also.
No.
So 1 is dead, 4 is dead.
One is the owner of the office that has deceased the, and due to that deceased has died. And 4 is the owner of the case where the deceased was traveling.
4 is the
Deceased was traveling. No? 4 is the owner of the vehicle where on which the deceased was traveling.
okay.
And the 1 is the owner of that vehicle that that's to the
Dashed. Any liability fastened upon the owners?
yes, no. For the respondent number 1, 70%.
So you have to substitute respondent number 1.
Respondent number 1. That I have already made the party in this. That
You
is
have
owner
to
of the
substitute him. Respondent number 1 is dead. Respondent number 1 is dead.
yes, no.
So
That
I have to file an IA for substitution.
I am the claimant now.
So then
Okay.
who will file the substitution petition? You may be the claimant, you are the appellant here. One of the respondent is dead. Now who will substitute? What will not substitute? The respondent also will not substitute. Who will substitute?
I by making certificate.
It has been reported that respondent number 1 and respondent number 4 is dead. Appellant should take necessary steps. This case is adjourned for 6 weeks.
Serial number 40, MN number 642 of 60, Mr. DC Ghosh.
No one appears in second call, adjourned for 6 weeks.
Serial number 20, MN number 426 of 80, Mr. DC Jha.
No one appears in second call, adjourned for 6 weeks.
The respondent of subsequent
Execute it.
let us stay.
will come.
Under the heading for admission, serial number 21, MN number 185 of 50, Mr. S. J. Roy for appellate, Mr. M. Lal for respondent.
Yes, Mr. Roy.
Doctor, in this case, respondent number 6, notice was issued upon him, but this is a wrong address. And the notice that has to be served is as per his policy. The policy is address is different. So the subscription has to be made on the correct address which is mentioned in the policy. That's why the notice is not getting served.
What do you want?
An amendment petition.
Also, appellate prays for some time in this case. We are allowed in this case after 3 weeks. 4 weeks.
Serial number 22, MN number 457 of 50.
Because in this case, on the last occasion, based on pertinent query, that whether the appeal loss, there is a provision of appeal as against the order passed in determination loss by the authority. The appellate provision is 45AA loss. 45A is the order by which the determination is made loss. Whether the order under 45A can be challenged under section 75 loss, that was the good question because there is one judgment I found from the Honorable Madras High Court loss, exactly same was the issue, and there it has been held that since the wording of section 45AA is with respect to may, it may not be treated to be compulsory minutes, and that is the reason an appeal can be entertained even directly minutes under section 75. That is the judgment in minutes. Before coming to the judgment minutes, I'll just invite minutes to the provisions of the ordinance. ESIC Act. This is the judgment minutes of the Honorable Madras High Court. ये reported नहीं मिल पा रहा था वो इसीलिए आया.
Let us see the provisions.
Minutes. Minutes में kindly have a glance first to 45A minutes.
45?
45A minutes. The determination of the contribution minutes.
45
45A minutes.
Determination of
Contribution in certain cases.
Yes, let us read this.
Minutes, it clearly says minutes that it lays down the procedure minutes for determination of the minutes.
Read the provision.
Minutes. Where in respect of a factory or establishment, no returns, particular registers or records are submitted, furnished or maintained in accordance with the provision of section 44 or social security or other the officials of the corporation referred to in subsection 2 of section 45 is prevented in any manner by the principal or immediate employer or any other person in exercising his functions or discharging his duties under section 45. The corporation may, on the basis of the information available to it, by order determine the amount of contributions payable in respect of the employees of that factory or establishment. Now the second proviso part is also there. Provided that no such charge shall be passed by the corporation unless the principal or immediate employer or the person in charge of the factory or establishment has given us a reasonable opportunity.
That's the opportunity of hearing.
Yes, because that is the reasonable opportunity.
And the period of 5 years.
The clause 2 is also relevant. It is well within the period of 5 years, that is also not the issue. An order made by the corporation, an order made by the corporation under subsection 1 shall be sufficient proof of the claim of the corporation under section 75 or for recovery of the amount determined by such order or any area of land revenue under section so and so, so and so, so and so. So it says that would be the sufficient proof of the claim of the corporation. The order made under 45A. This order is appealable before the appellate authority under 45AA. Now,
the order of determination.
The order of determination is appealable before the appellate authority, that is 45AA. May kindly have a glance to 45AA for a moment. If an employer is not satisfied, if an employer is not satisfied with the order referred to in section 45A, he may, the word is he may prefer an appeal to an appellate authority as may be provided by the regulation within 60 days of the date of such order after depositing 25% of the contribution, so order or the contribution as per his own calculation, whichever is higher with the corporation. Because it stipulates that within 60 days on deposit of 25% because that is maintainable under 45AA. That is the reason because in the order of determination also because generally in the taxing statute it is mentioned that this order is appealable under 45A. That is duly mentioned. Now because we kindly have a grant to section 75 for the powers of the ESI. 75.
Matters to be decided by
the Employees Insurance Code.
Insurance Code.
This is the. So, Millers, instead of invoking 45AA, Millers, I invoke Millers section 75 before the ESI. G would be the relevant part.
G. What is the difference between 75 and 45A?
So far, 75 because it is the power of the court because the difference because the wording says any other matter which is for a moment because I'd like to place that which is in dispute between a principal employer and
75 provides for the nature of dispute which has to be which can be decided by the ESI code. What are the nature of those disputes?
The nature of the disputes are
if the intention of the statute was to cover 45A in 75, then what was the necessity of promulgating said 45A?
That part is there because that is.
You answer this.
So far, that part is concerned because that is.
You answer this.
Because that is the reason I was relying upon the judgment of the Madras High Court because where this issue has been dealt with because my kindly. Because we kindly have three important paragraph 3 onwards, I'd like to just place the relevant particles. Here also the same thing had happened. The maintainability issue was raised by the ESI code itself. That once there is a provision of appeal under 45A, how this would be maintainable before the ESI code. The clause 3 paragraph 3 I am just placing this. The ESI code, without deciding the issue on merit, suo motu raised the question of maintainability under section 75 of the ESI Act and arrived at a conclusion that the petitioner has to exhaust the appeal remedy contemplated under section 45AA of the ESI Act. Therefore, the petition under section 75 of the ESI Act is not maintainable without exhausting the appeal remedy under section 45AA of the ESI Act. Because the reference has been made, because this is the issue precisely, and this has taken into account section 40.
Read
that. The paragraph 4 is in relation to whether the writ petition was filed here. I have approached under section 82 of the Corporation Act. That is not in dispute. Now, kindly have a glance to paragraph 5 where the interpretation is. The learned senior counsels,
yes.
The learned senior counsel reiterated that language used in section 45AA of the ESI Act is made. Section 45AA stipulates the appellate authority that if an employer is not satisfied with the order referred to in section 45A, he may prefer an appeal to an appellate authority as may be provided by regulation within 60 days of the date of such order after depositing 25%. Relying on the above language incorporated in section 45AA of the Act, the learned senior counsel is of the opinion that the word may employed in the provision is to be understood in normal context and therefore the effect of the word shall not be provided so as to compel the person to exhaust the appeal remedy under section 45AA of the Act. Relying on the said language employed in section 45AA of the Act, the learned senior counsel made a submission that the Labour Court committed an error in providing an interpretation more specifically the word may employed in section 45AA of the Act it cannot give a meaning as it is used in the statute, and the Labour Court has adopted may to be a meaning so as to arrive at a conclusion that section 75 of the petition cannot be entertained without exhausting the appeal remedy contemplated under section 45AA of the Act. Such an interpretation is in violation of the rule itself. The learned senior counsel contends that the second report of the Standing Committee on Labour so-and-so thought it fit to insert section 45AA, enabling the employer to redress his grievances against the order passed by the assessing officer. The said provision is an option to the employer, as his earlier remedy was to approach only ESI court. The provision was aimed at the reducing of the litigation in the court. The Amendment Act 18 of 2010, which followed the report of the Standing Committee on Labour, inserted many provisions and also made amendments with the existing provisions. Many provisions use the expression shall and few provisions use the expression may. The reading of the provisions which use the expression shall shows that it was mandatory, and provisions which use the expression may shows that it was discretionary. In the above context, section 45A of the ESI Act used the expression may as an option to the employer. The option can be waived by the employer and he can approach the ESI court under section 75 of the Act without exhausting the appeal remedy under section 45AA of the Act. Even after introduction of section 45A of the Act, the right of the employer to challenge an assessment before the ESI court under section 75 of the Act remains intact. Therefore, the order of the ESI court is perverse and contrary to the very intent of the legislation itself. The ESI court referred the judgment of the court dated so-and-so, so-and-so in the case of so-and-so, so-and-so. In the said judgment, the court held that the writ petitioner is at liberty to approach the appellate authority either under section 45AA or under section 75AA of the Act. Before the ESI court, even in paragraph 4 of the said order, this court held that with reference to the order passed under section 45A, the aggrieved person is at liberty to approach the appellate court or ESI court on account of the fact that the language employed in section 45AA is made. Thus, option is provided to the employer to approach the appellate authority or ESI court under section 45AA of the ESI Act. Such a right is to ensure that the statute cannot be otherwise interpreted by the ESI court, compelling the employer to approach the appellate authority under section 45AA before filing a petition under section 75 of the Act. The ESI court in its order referred to the judgment of the India Pistons case, the case decided by the Madras High Court reported in so-and-so, was with reference to the above judgment, which was followed by the ESI court for rejecting the appeal filed by the petitioner under section 75 of the Act. The learned presiding officer of the ESI court has committed an error in applying the said principle with reference to the option granted to the employer under section 45AA and section 75 of the Act. In this regard, the learned senior counsel distinguished the fact by stating that the judgment of Madras High Court in the case of India Pistons merely deals with a factual situation where a writ petition is filed challenging the order of ESI Corporation dated so-and-so passed under section so-and-so of the Act, which was disposed of with a direction to the ESI authority to rehear the matter on merits. In the above context, the judgment dealt with the introduction of section 45A of the Act, which is an appeal remedy available to the management. The court independently perused the judgment rendered in the case of so-and-so. In paragraph 8 of the judgment, the Supreme Court observed that the Act itself now provided under section 45AA of the amended ESI Act to go before the appellate authority. Admittedly, the orders including these writ petitions came to be made on 6/4/2010. Therefore, the petitioner can have the benefit of the amended provision, and obviously the appellate authority have not been notified under the regulation in terms of so-and-so. The petitioners can very well approach this court. On a reading of the entire orders in so-and-so, the court at no point of time had decided the language admitted in section 45AA of the Act with reference to the right of the employer to file a petition under section 75 of the ESI Act. Undoubtedly, both the provisions are providing right to the employer to prefer an appeal petition. Let us now look into the intent of section 75 of the ESI Act. The said section is not an appeal or revision or review. Section 75 is a special provision constituted in respect of the matters to be decided by the ESI court itself. However, section 75AA speaks about the appellate authority. Section 75AA is a choice granted to the employer. In the event of not satisfying with the order passed under section 45A, the employer may prefer an appeal to the appellate authority, admittedly, or appellate authority. Thus, it is only an option which can be exercised at the choice of the employer. The ESI court cannot compel an employer that the petition under section 75 of the Act will not be entertained in the event of not exhausting the appeal remedy contemplated under section 45A of the ESI Act. Such an interpretation provided by the ESI court is in violation of the intent of the provision itself, and when the Act in various other provisions use the word shall and it contains provisions the word may, then the court must be concerned with the language used to be the circumstances and that they have defined intention as well as meaning. which is to be interpreted with reference to the word used and not at the choice of the court. The other decision referred by the ESI court has also no application in respect of the maintainability of the ESI of the petition filed by the writ petition. In the case of so and so, the division bench of the court decided whether the writ petition filed by the government of Tamil Nadu was maintainable when an appeal remedy is provided under section 3022 of the NGT Act 2010 in respect of the order passed by the tribunal. The division bench held that an appeal remedy is available if the writ petition filed by the government was not maintained. With reference to the above judgments of the Honorable Division Bench, when the general principle regarding exhausting the appeal remedy is decided, it has no relevance with reference to the specific provisions of the SI Act. In respect of the general proposition, the aggrieved person has to approve the competent authority at the first instance for redressing their grievances or otherwise. Exhaust is the rule, and entertaining a writ petition before a court is an exception by granting waiver of an appeal remedy. This being the general.
I have understood this.
No.
You are harping upon 75.
Months.
Which provision of 75 you are taking refuge of?
This section 75 also says that if there is a dispute, if any question, the wording of 75 is that if any question or dispute arises to,
as to,
if any question or dispute arises as to
which?
As to, the rate of whether any person is an employee, that is not in dispute. The second, the rate of wages or average so the rate of contributions payable by principal employer in respect of any employee. The rate of wages, that is also there. The person who is the
what is your dispute?
My dispute is in relation to the adjudication of the amount, determination of the amount. My claim is that during the said period, the factory premises was not working, working, and it was closed. So if it was closed, there.
So you approach the ESI court.
Yes.
What is the order of the ESI court?
ESI court held it that since there is a limitation period, it held that it is barred by limitation, and there cannot be any.
Which limitation?
And now it is the limitation is also there. Kindly have a glance to one more provision, then I will come to the order passed by the ESI court. The provision, is 77 is the commencement of the proceedings.
Yes.
Yes, sir. The proceedings before an ESI court shall be commenced by an application. Now there is the 1A is very relevant. Every such application shall be made within a period of 3 years from the date on which the cause of action arose. The cause of action is 45-day determination.
So, if we read all this provision, then prima facie I am getting an impression that the matters before the Employees Insurance Court is of original jurisdiction in the nature of original jurisdiction.
Yes, that.
It's not by way of an appellate jurisdiction. But you are trying to exercise the appellate jurisdiction. Can that be?
That is one issue, where there
is the only issue.
The legislation, so far that part is concerned.
Can there be two forums of appeal?
That is what the Honorable Madras High Court has
asked.
The option was available, I exercised the option under section 75.
75 is the original jurisdiction.
Will appreciate one thing, there is a change also. If I exercise an appeal under section 45A, I am to deposit 45 to 25%.
Yes.
But if there is a appeal under section 75,
there is no question of appeal under
no,
75 is not an appellate
no, I'm sorry for that.
This 75 is
if I challenge any order.
75 is an adjudication of a title between the parties. You read A, B, C, D, E.
So for that part, will appreciate one thing,
yes.
that if there is, it refers to or any other matter which is in dispute.
No. Read 4. Don't read 4 words only. Any other matter which is in dispute between a principal employer and a corporation. Or between a principal employer and an immediate employer. Or between a person and the corporation, or between an employee and a principal or immediate employer. Now, in respect of any contribution or benefits or other dues payable or recoverable under this Act.
So, what will be
the recoverability is determined under section 45.
45A.
Then tell me if this was there. If as per you this is the appellate provision, why in 2010 45AA was incorporated?
Now the legislation provided another provision.
Earlier there was no
No
provision of
provision.
appeal.
No.
So this was in
This was there,
75.
but that
Now,
has been
a
inserted.
specific provision of appeal to challenge 45A has been given. Why? What was the intention of?
So for that part,
what was the legislative intention of incorporating 45A?
45A, that is there, but the option has been
No,
somehow.
why?
Even thereafter also an option.
Where is the question of option? When once you have already a provision of appeal, if you say the 75 is a provision of appeal, then why is it 7? What was the necessity of incorporating 45AA?
Because
what was the legislative intention of incorporating 45AA? Show me.
So for that part is concerned.
Show me. You have to answer this. These are the questions which I am putting to you. You have to be prepared with this.
Because that is an issue, the legislative intent we have
So legislative intent you have to come on to show.
Because Milords will appreciate one thing, Milords, that any dues, Milords, if 45, 75 G Milords makes it, Milords, that it can be recoverable under this act. So what is recoverable, Milords, is the determination under section 45A. So instead of invoking the 45AA,
in 45A what has to be? In 45A,
45A,
what would be the nature of challenge under 45A?
45AA Milords, the nature of challenge, Milords, as per this is 45A, the order of determination under 45A.
So when the statute has given you a provision to challenge a particular order by way of an appeal, so can you say that the other provisions will also include that?
Because what the statute, Milords, what the act says, Milords, we have to read, Milords, the golden rule of interpretation is also to the extent, Milords, that all the provisions has to be read, Milords, to the effect that it has to be given effect to, Milords.
Yes.
Now section 45A is there,
Yes.
Milords, and section 75 is also there.
75 is the matters which will not come within 45A.
So for that part is concerned, Milords will appreciate one thing else, Milords, that even section 77, Milords, provides for a limitation of 3 years for filing a petition under section 75.
Why 3 years? Why 3
Because
years?
there is a difference, Milords. If I invoke the section 45A, Milords, I have to deposit 25%. But if I invoke section 75, Milords, I have to deposit a sum of amount of 50%, Milords. There is an increase in the amount also.
Yes.
There is a subsequent, Milords, increase in the amount.
Maybe.
And that is the reason, Milords, there is the remedy, Milords, 45A, it provides 60 days. There, Milords, it is 3 years, Milords. Because if Milords, we have a glance to section 77 for a moment. For a moment, 77, Milords. That would help in the construction of 75 and Milords 45 also, Milords. For a moment, 77, may I invite Milords to beseech my Lord's kind attention to section 77. Because Milords,
Come to 75.
Milords.
The matters to be decided by the Employees Insurance Court.
Milords.
If any question or dispute arises as to
Whether any person is an employee within the meaning or whether he is liable to pay the employee's contribution.
yes,
That.
so it is the
Employee
who is the employee and who is the correct
employee.
employee?
Yes, Milords. I am not
Which an adjudicating authority,
Yes.
which a quasi judicial authority can decide.
Milords.
Just a minute.
The first one, Milords, I am only on.
Just a minute.
Milords.
Because this dispute can be decided by a judge, not by an
For a moment, Milords.
not by an this authority, because it's directly
relation between the employee, whether he is an
directly
employee.
false or it is a question of title.
Right. Yes, no, it's a question.
Now, second, the rate of wages. What would be the rate of wages?
That is
Or
also.
average wages of an employee for the purpose of this act.
Yes.
The rate of contribution payable by a principal employer in respect of any employee. The person who is the principal employer in respect of any employee.
Yes.
These are all adjudications.
Yes, these are all adjudications. Yes. The
Where,
right.
where a decision of a court is necessary. The right of any person, where deciding a right.
Yes.
Now, any direction issued by the corporation under 55A on a review of any payment of dependents benefits. If C, 55A has been incorporated.
Yes.
If that would have been the intention of the legislature, they would have incorporated that any direction issued under 45A also.
Yes.
It was not.
No,
it has
not there.
Any other matter which is in dispute between the principal employer and the corporation, or between the principal employer and the immediate employer, or between a person means a person at large, and the corporation, or between an employee and a principal,
or
immediate employer. Now, in respect to
of any contribution.
now, listen. These are the between so and so, between AB, between AC, between AD, or between DB, so and so. In respect of what? In respect of any contribution or benefit or other dues payable or recoverable under this act, whether your particular establishment was closed, running, that doesn't fall within.
So, for kindly have a glance to clause 45A for a moment.
Yes.
45A, the wording with respect to 45A.
Yes, let's go.
Why the provision of 75 was made over there?
Yes.
Milords, what that? Clause 2 I am referring to.
Yes.
45A. An order made by the corporation under subsection 1 shall be sufficient proof of the claim of the corporation under section 70.
Yes, absolutely. Now, if you say
Milords.
that order was passed,
Milords.
now if you say I am not the principal employer, I am no one.
For a moment further, I'll just like to complete the entire sentence. Milords. For the will be the sufficient proof of the claim of the corporation under section 75 or for
75.
75.
That means to invoke 75.
Exactly. Go.
So this order under 45A is a sufficient proof to invoke 75 for the disputes which are mentioned there in 75.
Or for recovery of the amount determined by such order.
Yes, who will recover? The corporation will recover. The corporation will recover, saying that there is an order under 45. This is sufficient proof for recover as land revenue. It will be recovered as land
by
land
such
revenue.
order as an area of land revenue.
Yes.
Right.
That order is sufficient to file a PDR case.
Plus I don't got that. What I respectfully submit before my lord.
So what this 45A, this 2, suppose an order has been passed against you. Now your case is that I am not an employer, I am not a principal employer, I am no one. So that will give you a cause of action to file a suit before for declaring that I am not a principal employer.
That is what I have also done.
Your ground is absolutely different.
Lords, I have challenged, Lords, the order passed in the determination and the notices, Lords, issued therein on the ground that I am not the Lords, the factory was closed, and this is a question how the determination can be made.
Factory
I was working as a contractor, I was not supplying this.
Factory was closed or not. Whether the establishment was closed, will it come? Is it covered under?
No, that
75. 75
says or any other matter which is in dispute.
Why are you reading only 3 lines?
Well, I'm not any
other matter which is in dispute
between a principal
AB, AC, AD, AE, or BC, BSO, so that is between. In respect of what?
In respect of any
The dispute is not limited. Dispute is limited to in respect of any. It is limited to any.
A to E.
In respect of
Milords is confining it to A to E, and I am harping on Milords G. Milords, it covers.
Yes, I don't know. I'm harping on G also.
Milords, because it says.
See, read like this.
Milords.
Any other matter which is in dispute, forget between the word, between any person.
A dispute.
In respect of, then skip everything and start from in respect of.
In respect of any contribution.
In contribution.
In respect of any contribution
So
or
is
benefit.
there any dispute in respect of your contribution?
No, Milords.
No.
Or
other dues payable or recoverable.
Milords,
There's no
or
dispute.
benefit. Or other dues payable. Or other dues payable or recoverable under this Act.
Yes.
So what is the recovery? How the recovery would be made, Milords, under this Act? So that only I have challenged, Milords. Because Milords will appreciate one thing, 77, the commencement of the proceedings also makes a reference to that extent, Milords, that what will be the claim, how it is to
Now, if you say that everything comes under 75, you are making 45 redundant.
No, Milords,
You are making 45 doubly redundant. Can a provision be made redundant?
No, Milords, Milords, what I am saying.
When specifically it says any order passed under 45 must be appealed under 45A.
No, Milords, if an employer, Milords, the 45A, the language
Yes.
of it, if an employer is not satisfied with the order referred to in section 45A, he may, the word is there, he may prefer an appeal.
He may not prefer an appeal also. He may satisfy.
Milords,
I am not satisfied, but I am accepting the order.
He may prefer, Milords, here.
He may. What does it mean? He may prefer.
Here, the Milords, he may and may not be, he may prefer an
He
appeal.
may. He may not prefer.
He may.
This may and shall.
It is not with respect to the Milords compulsory nature.
What has been held by the Madras High Court.
That is.
This is per claim, this per claim.
This
Can just tell me, can there be two appellate provision under the
Let
Act?
me just clarify.
You clarify this.
Now, my friend only sees 75(2) also. This will clear the position.
Yes.
What is, my lords, the point of law which is being raised, my lords, there was a clarification issued in year 2019 by the SI Corporation also, that 45AA or 75, both are permissible.
Subject to the subsection, the following shall be decided by the
So claim for recovery of contributions from the principal employer, it can be determined by the
claim by the principal or recover contributions from the immediate employer, claim against a principal employer under section 70, claim under section 70.
We are concerned with subsection 2 subclause A.
Yes, claim for recovery of the contribution.
Yes.
So, my lord, and there was in 2019, my lord, ESI Corporation came up with a clarification as well, saying that yes, 45AA and 75, both can be invoked. Both can be invoked. I'm arguing against myself, my lord, but in 2019, the ESI Corporation had come up with a clarification that 45A, there is a mandatory right of appeal under 45AA.
That has also been in the judgment also.
But still, the employer, the principal employer, may approach under section 75 challenging 45A.
So for that part,
to subclause A matters, because when there is a claim for recovery of contribution, the ESI court has got to it.
So you have initiated a proceeding for recovery.
This entire proceeding, even 45A order determination is also in terms of the recovery of contribution. There is a recovery.
Then you have to recover by way of land revenue.
Mallards.
Have you initiated a
This
proceeding?
is also done, Mallards, perhaps one has also been included.
Milords, one thing I just wanted to indicate, Milords. Milords, may kindly have a Milords, two paragraphs of the judgment, Milords, that letter which he is referring to, that has also been considered by the Madras High Court, Milords. 7/8/2019, Milords, the letter that is at page number 15, Milords, of the judgment. The letter page number 15, Milords. Paragraph 19, Milords. 15. Para 19, Milords.
Yes.
Milords, got that. The ESI Corporation, Milords, he is referring to this letter. The ESI Corporation itself issued a clarification note in letter dated 7/8/2019, which reads as follows. Either the employer can appeal under section 45A of the ESI Act, or he can directly approach EI court. No provision either in the Act or in the rules and regulations makes it mandatory for an employer to exhaust the appeal provision under section 45AA prior to filing an application under section so and so of the ESI Act. Had it been the legislative intent, it would have been specifically been provided for. In absence thereof, the arguments, if any, made that only after exhausting the option under section 45A can any application be filed in the EI court be accepted.
What is the necessity of 45A?
My lords, why this 45AA was passed, my lord? Your lordship, I pose the question. Many a times it was argued on behalf of the concerned employers that they were not afforded ample opportunity of hearing. Because in number of cases, my lord, in the earlier, my lord, we used to see that a single letter was written, and on the first day.
So those could have already been challenged in.
This could have been challenged, my lord, but what used to happen is the ESI court used to, after hearing the matter for 3 to 4 years, 6 years down the line, it used to relegate the matter back to the employer. Back to the corporation to again hear and determine the matter. Though it was competent to determine the matter in its original jurisdiction, the host 45 order.
Show me the rules. What are the rules in respect of this 70?
77, the commencement of the proceedings.
75, what are the rules governing 75 minutes?
Every minute's government, 77 minutes.
How the applications will be filed?
Minutes, that is 77 commencement of the proceeding minutes, then I will come to the rules. 77. Now here there is requirement minutes, every minutes got time. The proceeding before an ESI court shall commence by an application. Every such application shall be made within a period of 3 years from the date on which the cause of action occurs. The cause of action has already been described under section 45A, that is the date of determination of the amount. For the purpose of this section, because the cause of action in respect to claim of a benefit shall not be deemed to arise unless and until, because the B is relevant in this case. The cause of action in respect of a claim by a corporation for recovering contribution, including interest and damage from the principal employer, shall be deemed to have arisen on the date on which such claim is made by the corporation for the first time. Provided that no claim shall be made by the corporation after 5 years of so and so, the cause of an respect.
The claim has been made now.
Now the claim has been 45 days there. The claim has already been made. Every such application shall be in such form and contain such particulars shall be accompanied so and so. The fees part is there. It has to be accompanied with a deposit of the 50% of the contribution amount. Now, we kindly have a glance to the order passed by the ESI court. Two things are there. The order, two dates I will just indicate. 4/1/2011. 4/1/2011 is the date on which the claim under 45A has been made. The factual part.
Let me clarify, 45A determination is not a claim. It is the proof that there was a valid.
There was a.
There is a difference.
Yes.
The claim is the original C18 Act.
45A order is on 4/1/2011. That is already.
What is the 45A order?
Minutes.
And it's just 6, page number 41.
41. Minutes. Order under 45A of the ESI Act. Order under section 45A of the ESI Act, as amended, the order dated 4/1/2011. Page 41 I am referring.
41, yes.
41. Mr. So and so is an establishment clause under the covered under the ESI Act required to pay the contribution in accordance with section 40 of the Act, read with regulation 29 and 31 of the ESI regulations 50 framed under the Act. As the employer is in relation to this establishment failed to pay the contribution as required by law, a notice was issued to the principal employer by office order even number dated 11/11/2009 by registered entity to show cause within 15 days why contributions as per statement enclosed be not recovered from the employer was given an opportunity of personal hearing on 11/1/2010. Whereas neither employer nor his representative appeared on 11/1/2010 for personal hearing, again a notice was issued to the employer by his office, a letter number so and so even, and an opportunity of hearing was given on 3/2/2010, but neither employer nor his representative appeared on so and so. Again a notice was issued to the employer by office order even number dated then, and an employer opportunity was given on it, but neither. I have applied my mind to all the relevant facts and have gone through the records of the employer as available in the office. The factory establishment is covered under the ESI Act 1948, and the said employer failed to pay the contribution as demanded on ad hoc basis. Since the employer has failed to represent his case, it appears that he has nothing to say about the non-compliance and the due contributions is assessed. Therefore, I have been left with no alternative but to decide the case of no merit in accordance with section 45A of the ESI Act 1948, and it is to determine the contributions as per the notice dated 11/11/2009. This factory was covered finally with effect from 1/9/2007 on the basis of the Form 01, and no dispute has been raised by the employer regarding its coverage. Thus, the period for which the contribution has been demanded is undisputed. For the above reasons, also I directed is delegated to the BSI's thing and accordingly ordered the contributions totaling 1,80,180 for the period from 9/2007 to 3/2008 and from 6/2008 to 10/2000 are finally determined, and you are one of the principal employers are hereby ordered to pay the above amount within a period of 60 days from the date of billing, which this case shall be caused to be recovered under section 45C of the 245I of the ESI. If you are not satisfied with the above order and the determination of the contribution, you may prefer to file an appeal before the
So the
appeal.
demand is how much? 1,80,000.
Milords, 1,80,000.
With the interest also there will.
Milords,
After subsequent interest will have to be
now Milords, this order is of dated 4/1/2011. Thereafter, Milords, another date is very relevant, Milords. That is the date on which I have preferred the appeal before the Milords ESI court, and that is 6/6/2013.
6/6/2000.
2013. That is well within 3 years. Now the ESI court, the order of the ESI court is page number 71.
Yes.
Milords, for that page number 70.
It takes the dues from limitation period from from July.
Milords. No, Milords.
From 2007-8.
Milords, 7.
So that can't be.
that can be.
No, the limitation, Milords, why the dispute is coming on to that, Milords? The as per 77, Milords, the dispute under, if an application under 75 is filed, it has to be filed within a period of 3 years, Milords. And 45A is the point, Milords, when the determination has been made, Milords, and this is the order under 45A which I am referring to, Milords, 4/1/2011. Now I have preferred the appeal on 6/6/2013, but Milords, it says that it is barred by limitation. So my respectful
because they take the period, the commencement of the limitation from
no,
2007.
They are taking the period from the issuance of the demand, Milords. Issuance of the demand, Milords. So my submissions before my Lord's kind consideration, Milords.
This appeal will be heard on the following.
My Lord, can only see just for a moment. We need to clarify that this may not be heard. 77(1)(a) explanation.
Yes.
Now I'll place that section 77 for a moment.
Yes.
This is how.
Yes.
This is how the limitation when the commencement of the proceeding initiated and what is the error, because each statute has to be understood in the context in which it is to be met. I will take to place 77(1). The proceedings before an employee insurance court shall be commenced by application 1A. Every such application shall be made within a period of 3 years from the date on which the cause of action arose. Explanation for the purpose of this subsection. Now, what is cause of action has been determined, has been explained. The cause of action in respect of a claim for benefit. We are not concerned with the claim for benefit. We are concerned with B. The 2B. The cause of action. Oh, sorry, B. Only B. It was inserted. The cause of action in respect of a claim by the corporation for recovering contributions, including interest and damages, from the principal employer shall be deemed to have arisen on the date on which such claim is made by the corporation for the first time. So whenever we have issued a claim, that is sufficient for the purpose of cause of action. Now this is why this 3 years limitation is there.
Now
otherwise it wouldn't have been 3 years limitation. This is a special statute under the garb of a social security legislation, plus have the implements of a taxing statute as well. What happens is, when a claim is first made, from that date 3 years is to be counted. This is why this limitation was taken into picture. That's why 45A says that this is proof of claim. It does not say the claim. Had the tenure used in 45A would have been the claim. It would amount to claim, it would have been sufficient. It is proof of claim. Now, if there is a claim, thereafter 45A.
So when was your claim?
My claim was, as it is held by the State Insurance Code, if I am going to place it.
Eleven 2009.
11/11/2009. Where is that?
Internal page number 3 of the judgment at page number 73.
Means that is on record also.
No, your claim was under which provision?
My lord, the claim is under section 40 initially, my lords, that this is the ad hoc assessment. We issue a CET in ad hoc that look here, you are supposed to pay this amount. If he pays, that's sufficient. We are not supposed to proceed further. If he does not, then we initiate a procedure under section 45A. We are giving an ample opportunity of paying and determine the contribution. Now, 45A determination is not the claim. The claim is our initial demand letter addressed to the employer.
My lords may kindly have a glance.
No, how are you saying this?
My lord, what would be a claim in the normal parlance would be?
Suppose initially you claimed 1 lakh rupees.
My lords.
In determination it comes to 80,000 rupees.
My
Where your
lord.
first claim stand?
The claim gets modified. The claim gets modified pursuant to determination. But
No, tell me then what would be the
but my
claim?
lord, the period of
What would be the claim?
the period of
Limitation?
the period of
Can your period of limitation, you can say that will start from the date
but
where
it
you
will
have made 1 lakh
always, it
rupees.
will always start from the date when the first demand was made. This
Suppose
is the
you
tenure.
demand 1 lakh.
But in this case, this is not the case. In this
I
case,
am
this is
asking
not
you,
the
I am
case.
giving you a hypothetical question.
Right.
Suppose your first claim is of rupees 1 lakh.
My lords.
He doesn't reply, he doesn't file an objection.
My lords.
Then you determine,
My lords.
and on your determination you see that it comes to 80,000.
My lords.
What will be the effect of your first demand?
My lord, the effect of the claim would only be distributed with respect to the quantum aspect. Only the quantum has changed.
So don't you think if the quantum changes, the
Now the
initial
quantum has-
demand goes?
But the quantum has changed pursuant to a determination under by virtue of constitutional authority vested under the Act. This has not gone pursuant to a suo motu revision.
What do you mean by demand?
But
What are the essential
my-
ingredients of a demand?
let me take it otherwise. Let me take it otherwise, my lord. I pose the question to myself that if there is a normal money suit between the parties, and I issue a demand letter stating that this is XYZ, this is the claim. Now, thereafter some arbitral award, it makes that this is the final determination adjudication. Now, that under section 34, if the arbitral award is challenged, arbitral award becomes a challenge under within that jurisdiction. But in this particular case, there is no challenge to the 45A order pursuant to a statutory power.
No, he says that this 75 is maintained.
75 is maintained. I am not disputing that. 75 is
So
maintained. But now 75 is vis-a-vis the first demand. This is what the tenor used is. I read it.
What are the ingredients of a demand?
But the demand may be right or wrong.
No, just tell me. An arbitrary amount made in the demand will it stand?
But the demand may be right or wrong. This is why the limitation is for 3 years. The demand may be right or wrong. It needs an adjudication. This may be a wrong demand, but from the date when the first demand has been raised, first claim has been made, 3 years. This is what the limitation is there. This is why the reason of limitation is there for 3 years. Otherwise, had it been 45A AA challenge and thereafter section 75, a shorter period would have been specified by the statutory authorities. This is not the case that a shorter period has been specified. Conferring an original jurisdiction vis-a-vis the first demand is concerned. That's why the term used is
This
because
will be heard of the following question of law. Whether the period of limitation will commence from the date of the first demand.
first claim,
Or
the term used is first claim.
First demand made by the corporation. First demand of the claim made by the corporation, or from the date when the amount has been finally determined
Under section 45.
under section 45A of the Act.
Because I will not trouble you, because we kindly have a glance to page number 37. That itself is indicative of the fact that it is a proposed minutes. Because they have continuously used the word proposed minutes, that is the reason minutes.
Call the law records. Deposit. You have deposited.
That is what,
How much you have
50% is 50% is already there. That is not at all.
Serial number 23, MA number 228 of 60, Mr. Samak Kudorai for appellant, Mr. Manish Kumar for respondent.
In this case, Your Lordship, I have prayed for up to 1 week, Your Lordship, as because Your Lordship, the last occasion on 11/5/2022, time is given for the going go through the lower court record, but on 14th July summer vacation is started and today is the first day of after vacation, I said that only 1 week. In the meantime, I have gone through
What is the challenge?
enhancement,
On what basis?
Well, like the basis, they have said
What
that.
is your basis of the
Lots
appeal?
lots of the, like we have said that this, that they have calculated our income, 3,000 rupees per month, where an advocate is a that. And we have stated that his earnings.
This is the only ground.
No, no, after that, also, we have also said that although dependent is 6%, but he has calculated 1/3. Wife, 2 daughters, 1 son, and 2, mother and father. Is his mother and father.
Let us see the evidence.
The monthly income you also pays six.
Let us see the evidence.
Yes.
He is disputing that finding.
Yes.
Now, then, if he is disputing the finding arrived at by the tribunal, then I have to go through the evidence.
Yes.
Lots of.
Let's see what is the evidence.
For the Chennai, there is statement that required.
Very good.
It's just two paragraph goes to it, just there's nothing in your favor. You're not properly cross-examined him also on the quantum of salary. So there's a widow, 3 minor daughter and 1 minor son.
Yes.
5.
Father also.
Father
Died
is there.
during the pregnancy also.
The mother is with another brother, so he was not dependent on him. But still, if it is taken at 6, it should be 1/4. 1/4.
Accident of 2009.
Yes.
Future aspect also not considered also that if 6,000 rupees is fully increased. Another one point also we are raising that contributory negligence is found, but it was found that it was not anywhere it is found that it was otherwise having
So contributory negligence, it was
not mentioned. It was also found that FIR was filed and it was found that the person concerned was driving negligently, rashly and negligently.
What is the evidence? There is no evidence to this.
No, the FIR has been lodged and in the FIR it came that fine it also it was only the relevant part is that the charge.
Let it go.
It also be the claimant, the widow, himself admitted that in the motorcycle 3 persons were riding at the time of accident.
Not 3. 2 and a minor daughter.
That is their personal accident.
The deceased was driving the motorcycle. The pillion rider was his bhabi, and 1 minor daughter was on the lap. Now, come to the finding. There is no evidence of contributory negligence. Now come to the finding at page 5, internal page 5 of the judgment, para 12, last paragraph. How can this be sustained? It says, just since the deceased was not wearing a helmet, so is it your case that if you would have worn a helmet, you would have been safe? Admittedly, there is a finding that admittedly the truck dashed from behind.
Yes.
Truck dashed the motorcycle from
Yes,
behind. I am disposing
Back side or rear side?
rear side. So
Rear side.
the truck dashed the motorcycle. It is not that the motorcycle dashed the truck.
Finding of the charges is also there.
Third, the counsel for the appellants, Mr. Prashant Kumar Singh, and Mr. Amrish Kumar appearing on behalf of the insurance company. And I have also gone to the local records. This is an appeal preferred by the claimants of the appellants, praying for enhancement of the amount of compensation awarded to them by the District Judge 3, MACT Dhanbad, in title MV suit number 215 of 2015, by award judgment dated 14th December 2015. Stop. Same matter. By the award, the tribunal has awarded a sum of rupees 2,90,000. 2,90,000.
Loss.
2,90,000 as compensation on account of death of deceased, namely Shirodhar Mahato, who is the husband of claimant number 1, and the father of performer respondent number 3, 4, 5. And son of appellate number 2 and appellate number 2. Three, four, five again. 3, 4, 5, and 6. 3, 4, 5, and 6, and son of appellant number 2. Next one. The counsel appearing on behalf of the appellant argues that the quantum of compensation assessed by the tribunal is much on the lower side, as the tribunal failed to take into consideration that admittedly the deceased was a truck driver and was earning rupees 6,000 per month by way of salary. As per him, the calculation of compensation on a monthly income of rupees 3,000 is against the evidence which has been laid by the parties. He contends that the court, without any basis, has fixed the income of the deceased as rupees 3,000 when the evidence was contrary. The evidence of the court is contrary.
Reasoning is given in balance. Wait.
He submits that he further submits that by paragraph 12 of the judgment, 25% deduction has been made from the amount of compensation on the ground, after holding that the deceased was also negligent and he also contributed to this accident. As per the counsel for the appellant, this finding is absolutely bad and is against the evidence. He submits that the findings in paragraph 12 was self-contradictory. As in one hand, the tribunal has held that that the deceased was also negligent, but a finding has been arrived at that while the deceased was riding a motorcycle, the offending vehicle, which is a truck, dashed the motorcycle from behind. As per him, on the aforesaid fact, it cannot be held that the deceased was negligent. The appellant submits that there is nothing on record to suggest that if the deceased had owned the helmet, his life would have been saved. That being so, the finding of the tribunal, so far as it relates to contributory negligence, is perverse. He also submits that taking into consideration the dependents, the amount, the deduction on account of personal expenses should have been 1/4 1/4 and not 1/3 as calculated by the tribunal. These are the only grounds taken by the appellant wherein he has prayed to enhance the amount of compensation. After setting aside the finding arrived at by the tribunal in relation to the contributory negligence. Mr. Amrish Kumar, appearing on behalf of the insurance company, submitted that the appellants failed to produce any document in relation to the earning of the deceased. He submits that even the driving license of the deceased was not produced before the tribunal. In absence of this driving license and the documentary evidence, the tribunal has correctly assessed the income of the deceased to be rupees 3,000 per month. More so when the accident had taken place in the year 2009. So far as dependency is concerned, he submits that the mother-in-law is admittedly dependent of another brother, which is evident from the evidence adduced itself. As per him, the tribunal has correctly deducted 25% on account of, 25% on account of contributory negligence, as admittedly the deceased was not wearing a helmet.
And claimant has also said there is a 3% riding in the process.
As per him, from the evidence, it is clear that there were three persons who were traveling in the same motorcycle, which will attract the concept of contributory negligence. Next. I have heard the parties and I have gone through the lower court records. The deceased Hirodhar Mahato was returning to his house from a marriage party. After attending a marriage ceremony in the motorcycle bearing registration number J802A9899, and along with his sister-in-law Aruna Devi and a minor cousin. When he reached near Sadoro More, Sadoro crossing, Sadoro crossing, on Bishungar Gomia Road, a truck bearing registration number JH02F, capital F, 4911, which was driven in a rash and negligent manner, dashed the motorcycle from behind. As a result of the impact, the deceased fell out from the motorcycle and after sustaining grievous injury died on the spot. The pillion rider Aruna Devi and the minor Bharati Devi also sustained injury. A claim application was filed by the wife, minor children, father-in-law and mother-in-law. Claiming compensation, stating therein that the deceased was a truck driver by profession and was earning rupees 6,000 per month and was aged 30 years at the time of the accident.
Claimant is only mother-in-law.
The mother-in-law. Father-in-law's name was deleted.
During the pendency, you got.
Father-in-law's name was deleted. Father-in-law, right? Claimant क्या किया? we noted that the father-in-law was deleted from the loss diagram as he died during pendency of the claim application. What's the next paragraph? It is to be noted that Bishungar PS case number 46 of 2009 was instituted as a result of this accident, which was registered under section 279/304 capital A, 337 and 338 of the Indian Penal Code. After investigation, charge sheet number 87 of 2009 was filed by the investigating officer.
पारा 11 का लास्ट, पारा 11 का लास्ट।
Well, the charge sheet and exhibits.
Two.
Yes,
Exhibit 2 is certified copy of charge sheet of cable.
File the charge sheet finding. The driver of the offending truck responsible for the scene accidents. Next one. After filing and registration of the claim application, the insurance company appeared and they filed their written statements. The fact that the offending truck was insured with the insurance company was not disputed. Witnesses were examined on behalf of the claimants. Documents like the FIR of Bishungar PS case number 46 of 2009 found in the charge sheet was exhibited. The certificate of registration of the vehicle of the offending vehicle and the insurance policy was, the certificate of insurance was also exhibited. The postmortem report was also exhibited to prove the fact of the death. The tribunal thereafter, the tribunal thereafter, considering the evidence on record, assessed the income of the deceased as ₹3,000 per month, and after applying the multiplier of 16, deducted 25% of the amount of compensation on the ground that the deceased also contributed to the scene accidents. Thereafter, directed payment of compensation to the tune of rupees 2,90,000. ऊपर भी लिखा ना counsel for the appellants, एक जगह लिखिएगा that counsel for the appellant further draws attention to this court, relying upon the judgment of Pranayaship T. so and so. And submits that the tribunal and the appellants are also entitled for an additional enhancement on account of future prospects and also on account of funeral and other expenses.
Funeral only 2,068,000.
The only ground taken in this appeal is the quantum of what would be the correct quantum of compensation. From the impute judgment, I find that the tribunal has held in paragraph 13 that the monthly income of the deceased is rupees 3,000. This conclusion has been arrived at by the tribunal on the ground that the deceased failed to produce any paper which suggests that he was earning rupees 6,000 per month. The tribunal also held that the driving license was also not produced. Driving license of the deceased was also not produced. Thus, the tribunal arrived at a conclusion and was not produced. Full stop.
Clement has claimed that the deceased was a driver, except the license support.
It is the reasoning of the tribunal that since the deceased was a driver, since it is the case of the appellants, clearly that the deceased was a driver, the claimant should have produced the driving license to convince the tribunal that actually the deceased was a driver and was not unemployed. From the record, I find that admittedly there is no document in proof of the income, nor the driving license of the deceased is on record. The only material which is available is the oral evidence. So PW number 1 is Chameli Devi, who is the wife of the deceased. In paragraph 3, she has stated that the deceased was her husband, who died on 3/5/2009. She further stated in the aforesaid paragraph that she further stated while depositing in the aforesaid paragraph that the deceased was driving truck/dumper and his employer used to pay rupees 6,000 per month as salary. The deceased was maintaining his entire family out of this said salary. In paragraph 4, she states that the deceased was having a valid license to drive the truck, but the said license got misplaced or bit lost at the place of accidents. In paragraph 5, she states that her husband, along with the sister-in-law and a minor child, girl child, was returning to their house when the offending truck dashed from behind. On receiving the aforesaid information, she rushed to the place of occurrence along with others and saw the dead body of her husband. This witness was cross-examined. In cross-examination, no positive question was put to counter her statement. Statement in relation to either the driving license or the income or the fact that the deceased or on the fact of the employment of the deceased. In paragraph 18, merely a suggestion was given as which the witnesses denied. PW2 is one Raju Mahato, who also stated that the deceased was a truck driver, and was earning ₹6,000 per month. This Raju Mahato also was cross-examined, but no positive question was put to him. Rather, a denial was obtained on the suggestions, as it was done in the case of PW1. PW3 is the sister-in-law who was the pillion rider. When the accident had taken place, she stated that she was the pillion rider of a motorcycle which was being driven by the deceased Kirodar Mahato. The minor girl child was along with them. Her minor girl child was along with them. She stated that the truck dashed the motorcycle from behind. Our truck bearing registration number JH02F4911 dashed the motorcycle from behind, resulting in the accident which caused death of Kirodar Mahato. She also in paragraph 5 stated that the deceased was earning ₹6,000 as he was driving a truck. There is nothing in the cross-examination to disbelieve the evidence of speed of road. Thus, from the evidence, after analyzing the evidence, I find that though there is no documentary evidence in support of the income of the deceased, but there is a consistent evidence of all the PWs that the deceased was earning ₹6,000 per month and was maintaining a family consisting of which consisted his wife and 4 minor children and the mother. There is nothing to dispute this statement so far as it relates to the income of the deceased. Thus, since there is no contrary evidence to suggest that the deceased was not working or was unemployed, there was no occasion by the tribunal to assess the income of the deceased at ₹3,000. This error has been committed by the tribunal. When there is this positive evidence that the deceased was a truck driver and was earning ₹6,000 per month, the tribunal would not have assessed the income of the deceased at ₹3,000. Thus, this court holds. Thus I hold that the income of the deceased was ₹6,000 per month.
Which is the accident of 2009 years.
Yes, sir.
And the judgment is the cited in the judgment university for 2014 at 3,000. Any supporting document has not been given. Even the employment is also not given. Nothing has given. My approach.
Now the question which is to be decided is about the contributory negligence. The tribunal has held that since the deceased was not wearing a helmet, the amount of compensation should be reduced by 25%. I mean, this court fails to accept the aforesaid theory. To assess the contributory negligence, one has to see, it has to be seen as to what was the amount of what was the negligence on the part of the deceased as a result of which the accident occurred. In this case, from the evidence of PW3, who is the eyewitness to the occurrence and was also an injured witness, it is clear that the truck, which is the offending vehicle, dashed the motorcycle from behind. Further, the charge sheet also was filed against the driver of the offending truck. The manner in which the accident has taken place clearly suggests that it is the driver of the offending truck who was negligent. When a vehicle dashes a motorcycle, when a truck dashes a motorcycle from behind, resulting in death of a rider of the motorcycle or a pillion rider, it can't be said that the rider of the motorcycle was at fault. Thus, I hold that the deceased was not at all responsible in any manner for the accident which has occurred. Further, there is nothing on record to suggest that the deceased would have been alive if he would have worn the helmets. Thus, the finding arrived at by the tribunal so far as it relates to issue number 5, which deals with contributory negligence, is set aside. As the same is against the evidence. The Honorable Supreme Court in the case of Meera Devi and others versus so-and-so 14.4.511 in paragraph 10 has said that to prove contributory negligence there must be a cogent evidence. In this case, rather there are cogent evidence to suggest that there was no contributory negligence on the part of the deceased, as uske baad likhte na PW1. Next one. Further, from the imputed judgment, from the imputed judgment, I find that the tribunal has not awarded any amount on account of future prospects. The funeral expenses awarded is rupees 2,000, which is also on the much lower side. Conventional rate, nothing has been paid.
2,000 now.
No, only funeral expenses.
68,000 in hand.
Thus, next line. Thus, the quantum of compensation needs to be recalculated. Further, I find that an amount of rupees 1/3 has been deducted on account of personal expenses. Admittedly, the deceased has left behind 6 dependents. Thus, as per the judgment of the Honorable Supreme Court, on account of personal expenses, the deduction would be 1/4 and not 1/3. Now, what has been held above? Now, in view of what has been held above, the amount of compensation needs to be just a minute. As for postmortem, what is the age of the deceased? $30. So, legal. Okay. The multiplier applied in the instant case is 60. Applied in the instant case by the tribunal is 60. What's up? The deceased is aged about 30 years. First off, the claimants also claim that the deceased was 30 years. The postmortem report also says so. First off, that being so, the multiplier would be 17 in the instant case. Considering what has been read above, the amount of compensation needs to be recalculated as follows in terms of the judgment passed by the Honorable Supreme Court in the case of Pranay Shetty and others. 6,000 into 12 into 17 equals to so and so, less 1/4 so and so, total so and so. Add future prospects 40% so and so. $70,000 conventional rate so and so. Thus, on recalculation, the total amount of compensation comes to so and so.
Compensation amount, awarded amount is already paid.
The insurance company has paid a sum of so and so. 2,90,000. Thus, the claimants are entitled for a balance amount of rupees so and so. this balance amount will carry an interest at the rate of 7% from the date of the award, that is 14/12/2015, till the same is paid.
That's it. We are not, this case is 2009,
2015.
and 15 is the judgment, Your Lordship. And now we are in 2022, Your Lordship. As such, the interest part is on the insurance, Your Lordship.
7%.
The insurance percent, you will see the long period, Your Lordship. No fault of insurance company. They have awarded, I have paid. And this case is filed on
You took the benefit.
2016.
Mr. Counsel, your company took the benefit of award which is incorrect.
That is
Number
there,
one.
Your Lordship, but
Number two, what do you think this local adalats are for? It is more for the insurance company than the claimants. You should have availed that opportunity.
Your Lordship, on that point, Your Lordship, my submission may be noted that the 3,000 to 6,000, Your Lordship, my submission may be noted.
It's here there, it's a submission is already there.
Well, only that, but Your Lordship.
I noted it. The appeal stands allowed, therefore said extent. Here I have gone through the explanation submitted by letter number 147 dated 22/3/2022 by the judge in charge, Civil Court, Dhanbad. The principal district judge Dhanbad is directed to caution the process servers and the Nazarat clerks and ensure that in future the notices will be served the appropriate respondents without any matches in a proper manner. Let this be communicated to the PDG.
Serial number 24, MN number 408 of 16, Mr. DC Goyal for applicant, Mr. Sundar Singh, Mr. Indranjit Sinha for respondent.
Where is the applicant? Pass over.
Serial number 25, MN number 551 of 16, Mr. Neeraj Kishore for applicant, Mr. Pratish Kumar, Mr. Prashant Kumar Srivastava for respondent.
Condition is appeal also. Respondent number 2 has died also. We have filed one I number 4113 of
4113 of 2022.
minor.
Your subsequent declared on now 600 number 3. I have to file a third binder of that item for 2032 so as to delay is of 1155 days.
Well, we got the council appearing on behalf of respondent number 3 submits that he wants to file, his client wants to file a rejoinder to IA, rejoinder to the IA 4113 of 2022. They are allowed, is this case after?
2 weeks.
3 weeks.
Okay.
Serial number 26, MN number 170 of 17, Mr. DK Mishra, Mr. Subham Mishra for applicant, Mr. Gautam Nagel for respondent.
Your Lordship, I
Please, this case I'm hearing for orders. Hearing for orders.
Your Lordship, I'm appealing for, Your Lordship, I was paying for not.
Wait.
Your Lordship, the RBI office, I had to go to his home for some medical investigation.
Because the issue involved was last time this matter was taken up with. Well, the issue involved was with regards to payment of the interest. That from which date the interest has to be paid.
This is only the interest.
Millets, they have raised the contention with regards to the quantum as well, Millets. Whether the quantum should be 3,60,000 rupees or 3,20,000.
Amputation.
Millet.
It has been submitted due to some medical emergency. Mr. Shiva Mishra, the Army Council, on behalf of the applicant, has to leave court. That's fine. Next week?
Okay.
Is this case next week?
Okay.
Much okay.
Serial number 27, MN number 245 or 70, Mr. Vijay Shankar Shah, Mr. Anish Kumar for appellant, Mr. Gautam Rai, Mr. Vijay Kumar Sinha for respondent.
May please Lordship. This is a case file arising out of railway claim criminal matter. Earlier it was heard matter. The time was granted to the respondent for inspection of record matter. My case is my lord at about page 25 my lord. Observation has been made by the criminal matter. Para fourth my lord. DRM's report exhibit 12 also
Use
does
the microphone. Use this
my lord.
Yes.
Observe my lord. DRM's report exhibit R2 also does not support the case set up by the applicants. It does not support the case of fall from train. Next my lord. Since the accident fall has not been proved by the applicants, therefore the presumption regarding the loss of ticket cannot be drawn in favor of the applicants. On the point, my lord, matters have been dismissed, my lord. And you are permitted to submit some documents, my lord. Recently, my lord, Exhibit 1, my lord. Yes, my lord.
Exhibit 1.
Exhibit 2, my lord.
Exhibit 2.
Page 17, my lord. Of my petition, my lord. You are appeal.
Page.
The further beyond of the.
Yes.
Well,
yes.
हमारा नाम सो समक्ष बिना किसी के दबाव के अपना बयान दे रहा हूँ। रेलवे स्टेशन श्री नारायणपुर को संख्या 1600 दिनांक 9/6/13 समय 1600 मोहम्मद शमशाद मेरा छोटा भाई है। ये ईस्टर्न रेलवे रेल यात्री संघ भागलपुर के एम्बुलेंस के चालक हैं। यह रात्रि में कभी कभार ड्यूटी एम्बुलेंस रखकर भागलपुर तिरुपति में अपने घर सुंदरपुर तिरुपति रात्रि में जाते थे। ट्रेन से किसी अज्ञात ट्रेन से जब ट्रेन शिवनारायणपुर स्टेशन से करीब 4 किलोमीटर पूरब प्रस्थान किया। 200 कोड संख्या 262-45 के समीप तो किसी अज्ञात ट्रेन से गिरने से कटकर के मेरे भाई मृतक शमशाद का मृत्यु हो गई। This is the first born of the.
He was not an eyewitness.
No,
no, which train he had boarded.
Last matter and the final report matter.
From where was the dead body recovered?
The relevant matter, exhibit 4 matter, page 20 matter.
This again will be
अगर 2 days
admit.
इसमें इनको एचसीआर को इंस्पेक्शन के लिए टाइम भी लगेगा।
We have got the record.
Clear.
final report, my lord, that says that.
I have admitted it. I have not dismissed this.
Serial number 28, MN number 564 of 70, Mr. Prashant Vidyarthi for appellant. Mr. Alokal correspondent.
Lordship, I say for thought possible and Mr. Prashant Vidyarthi relates
In this case, after 2 weeks stand to file Wakalatnama.
Wakalatnama? Behalf of whom?
On behalf of Mr. Alokal. Yesterday dismissed.
Behalf of Mr. Alokal. Alokal has already appeared.
The copy has been received for Wakalatnama.
He appeared on 9/5/2022. He appeared on 24/2022. What is this case?
Sir, I am not aware. The last case on is report number 3 years.
Yes.
It is the appeal is by the Union of India.
Yes, sir. In this case, the pensions have not been appreciated. In the FIR, it has come, not been erection. The FIR has come that
You are only concerned about this 50% of the amount.
mainly our contention is that there was no fault on our side. Our contention was the total fault was on the part of the other vehicle. Not been closed. It has
Other
come.
vehicle which is insured with Mr. Alok's client.
Yes, yes.
LCR है?
LCR नहीं मंगवा लें। FIR में क्लियर कट आया है कि उनकी लापरवाही से जाकर उनकी गाड़ी में घटना हुआ।
FIR will
नहीं होता।
have a piece of evidence.
नहीं होता।
What is the evidence?
इसमें आया नहीं है।
What is the evidence?
It does not come in the written. Driver of the jeep, which the driver of the jeep, the rashly and negligently entering the report dashed with the military van coming from the opposite direction. That's come in para 5 होगा. The owner has appeared and is taken.
How about the local records? To appreciate the arguments of the learned counsel appearing on behalf of the appellants, that it is that the military vehicle was not at all responsible for the accident. Come on. It is necessary to call for the local records.
Serial number 29, MN number 677 of 70, Mr. Sudhir Khan, Mr. Nitul Kumar, for appellant, Mr. Manish Kumar, for respondent.
Regarding this case, I have received 3 weeks time.
Why?
Because my client has instructed me that he is managing money as per a lordship's order I have to file.
Last order was
Last order was to file 40% of the amount.
So file
I was directed to file 40% of the compensation award as per the implement order. Because my client is managing money because
How much time?
3 weeks time.
The request of the learned counsel for the appellant, on the ground that his client is arranging some funds. What is the award?
60% has to be paid by the insurance company, 40% by the
By the
owner.
On what ground?
Contributing.
overloading
Because he was traveling on the road. But the question is not in traveling on the rooftop was also negligent of the part of the disease.
No.
So, I will demonstrate to doctor.
They have not challenged right to recovery given.
No, my lords, I have written the company, my lords, and I will the Shukti Thankar in ground.
Then आप कुछ फाइल नहीं करना है. I will not give you this opportunity. हम आज ही dispose कर देते हैं. On the request of the learned counsel for the appellate is this case after 3 weeks.
Serial number 30, MI number 112 of 80, Mr. Manish Kumar for appellate, Mr. Chandradev Singh for respondent.
In this case, the level control on the last date members.
Yes.
In case members where there were no permit or driving license and SCR will be required in this. We have taken specifically, but
Let us see the judgment.
paragraph 3, my lords, will see kindly. Page 14.
Running page
14, my lords.
14, yes.
There are 3 I am placing. In this case, in spite of this case of shortlist to register both OP2 owner and OP3 driver did not appear, things were not responding against them. However, OP1 within the assurance company appeared and filed showcall on 20th August 2008. In showcall, OP number 1 had denied calamity.
The appellant submits that the offending vehicle was being driven without permits and also without other statutory documents. It is a case, it is a case of the insurance company that in absence of these documents, it is a case of the appellant insurance company that since the vehicle was being flying on the road without the statutory documents, the insurance company is not liable to indemnify the owner. He submits that the right to recovery should have been
Yes.
मिला है नहीं मिला है?
नहीं मिला.
Should have been granted in favor of the insurance company. Considering his submission, notice to the owner of the vehicle.
6 and 7 by lords, owner and driver.
Driver, what will the driver do?
Yes.
Notice to the owner of the vehicle, that is respondent number 6, registered ordinary both process. Full stop. In the meantime, the insurance company should satisfy the award as the best relief which the insurance company can get from this court is the right to recovery.
Yes.
Requisites to be filed within 3 weeks.
Okay.
Serial number 31, ML number 130 of 80, Mr. Alok for appellant, Mr. Jayadama, Mr. Rahul Kumar for respondent.
Wait. Where is Mr. Lal? What is the ground? What is the ground? What is your ground? There was no insurance policy.
No, because there was the insurance policy. Yes, that is there. The 2 grounds they have taken, Milords, is precisely first that the JCB is not covered under the Milords policy.
And the second is that there was no third party insurance to the extent of 44 lakhs. It was only confined to 2 lakhs. 2 lakhs 6.
What was covered?
Because they have stated notes in the judgment also it has come.
It's insurance for the machineries.
Insurance of the plants and machinery. Contract plant and machinery. Precisely.
So then?
That is already covered because they have accepted that part. It's covered.
No, it's covered for the machinery. For what purpose? Under the MV Act?
Milord, under the MV Act.
Where is the policy? LCR is there? How about the local records? Since the counsel for the applicant submits that the policy was not under the Motor Vehicles Act, rather the insurance was extended. Was the insurance policy was for covered plant and machinery,
Contractors, plant
and not the motor vehicle.
The right to recovery is also there in the document. That is there.
Right to recovery is there.
There.
It
Is there? It is there.
It is there. Let the LC.
And then check.
Serial number 32, MA number 328 of 80, Mr. Amar Kumar Sinha, Mr. Sandeep Verma.
Where is Mr. Kumar Sinha? Pass over.
Serial number 33, MA number 348 of 80, Mr. Amit Kumar Das.
On the previous occasion, Your Lordship, time was handed to us to find out whether any appeal was preferred for the two persons, that husband and wife. So any appeal was preferred for the claim petition that was filed on the so that was preferred. No appeal has been preferred, and the awarded amount has been already given and paid to the claimants.
So there were two deaths arising out of the same accident.
Yes.
The husband and the wife both died.
Yes.
So you have satisfied the award in respect of the
husband.
So what is the ground for the wife?
There are two grounds, Your Lordship. The right to recovery has already been granted to us. It is not disputed. Two grounds that we have taken. One, there is no evidence to show that the lady was working as a tailor or doing her business of tailoring, and 4,500 has been granted. And the claimants are showing themselves to be dependents. Our father-in-law and mother-in-law, who were also dependents on husband of the deceased here.
So there cannot be a dependence.
These
This
are
is the only grounds.
Yes.
So there is no children.
No, Lord.
Sure. So how much amount has been awarded? 8 lakhs.
In the previous
Issue notice to the respondent number 1 and 2 registered 1, 2 and 3 registered ordinary requisites 3 weeks. Both the system. Part of the local records. Oh yeah. Local record is here.
Serial number 34, MA number 535 of 80, Ms. Lakshmi Mishra, Ms. Nitu Singh for appellant, Mr. Manish Kumar for respondent.
Yes. enhancements.
My Lord, on honest ground, the claim as against the accident, 60% disablement, left leg, my Lord, below knee was amputated because of the accident. And my Lord, the case was filed after 5 years. Now the ground on which summarily he dismisses the claim case, my Lord, is that after 5 years you are coming, and then, my Lord, he says that you could not make out the death caused by the accident.
Death?
Which was not the issue.
Is it a case of death or injury?
No, injury. My Lord, after 1 month he died of the filing of the case. After filing of the case, my Lord.
Which case?
The claim case. Claim case was filed, my Lord, in November 2011. Accident is of 8.
2010, you had taken 140. What was the case number?
Pardon, sir?
There were 2 cases instituted.
Here, my lord, one rupee case was instituted, he received 25,000 rupees. Then, my lord, he filed this case in 2013 in the month of November. Subsequently, he died in December. Then, my lord, it appears from the provision of the order that there is error in so far as it is claimed that the case was for death claim. It was not a death claim, it was injury claim.
This was the injury claim.
Injury, my Lord.
But SCR may be called for my lord to verify.
So on honest ground, my Lord.
No, there is one ground is also there that there was disablement certificate of 2008. Case certified in 13, whether disablement certificate for that period or not. And my email is saying that there was amputation of leg. So if that be the case, then this finding is also not correct. So the SCR will be called for.
Call for the lower court records as the case relates to amputation of leg.
My Lord.
I submitted by the
As submitted to the lower council for that.
Serial number 35, MA number 555 of 80, Mr. A.J. Sani for appellant, Mr. Malinda for respondent.
In this case, Your Honor, the lower court records were called for by order dated 11/5/2022, which had been postponed received. Ready? Sorry, no. This is an application, Lord. This appeal arises out of an order.
was not called.
No, sorry, Lord.
Last date पे appeared so.
My learned friend appeared on behalf of the respondent number 1 and 2. So far, other 2 respondents are there, Lord. A probate case was filed by the respondent number 1 and 2, in which, Lord, this present appellant being the brother of the respondent 1 and 2 was the opposite party number 1. Lord, now look at the so far opposite party number 2 and 3 are concerned. They are the brothers of the deceased father of the particular respondent, the present appellant and the respondent 1. Now, the probate case, Lord, in probate case, the notice could not be served upon the present appellant, and therefore, Lord, the step was taken, Lord, for substituted service, not by
So this misappeal is against an order.
Against an order
9/13. Refused to restore.
Set aside the
Set aside the ex parte.
ex parte judgment. Now, the ex parte judgment, Lord, immediately having come to know about it, Lord, annexure 4, page 27, a petition under order 9/13, reading section 151 was filed by the present appellant, and it was supported by his evidence as
So what is the finding? Let us see.
Yes, you know, see, my kindly come to then first and then 13.
What is the tenor of the ex parte judgment? The probate was granted.
Probate was granted. The appellant is also one of the brothers of the respondent 1 and 2. So far,
The will is in her favor.
in favor of the her client.
In favor of our client.
Yes.
Now,
Lord,
what is the ground of your challenge?
challenge, Lord, that the explanation which has been given. Now, the landed court below says that the paper publication is sufficient, and for to know that he has knowledge and he did not appear, he could not explain. That is not correct, Lord. It is error of record.
No, I am asking you what is your ground to challenge the will?
Probate.
Yes.
Probate, Lord, that the will is not correct one because he did not get the chance to file his written statement even he could not appear. And the learned court below says that the substituted service, the paper publication was sufficient. The onus is not to prove that sufficient cause has to be given by the
Succession Act.
Para 10 and 13 are the ground not to refute to set aside the ex parte.
File a petition for revocation.
But that means one of the remedies available to him
File a petition for
they can
revocation.
resort to the provision because it once the probate has been granted. Now the
can file a
probate
petition for
number the
revocation.
ground on which the prayer was refused, but that is also an error of record and is not sufficient. The Lordship just see para 10.
Para 10.
10 and 13.
Yes.
Okay. In this regard, that is not page 7, but running page 7. Learned counsel for the opposite party submitted that the applicant had full knowledge regarding tendency of probate case and deliberately he did not appear before the court to contest the probate case. He has submitted that the process server has clearly reported that he acquainted the applicant regarding issuance of notice against him and after going through the contents, the applicant refused to accept. That is not the correct statement. The process server submitted his report otherwise. Then he has further argued that other opposite parties of the probate case also reside in the same house and they had appeared in probate case which clearly they have supported the presentation of 1 and 2. They that notices were served upon the opposite party. Yes, sir.
Counsel for the appellant submits that the finding arrived at by the Municipal District Judge Dhanbad in the impugned judgment dated 30th July 2018 passed in civil miscellaneous case number 10 of 17 so far as it relates to the report of the process servers is an error of record.
Yes.
Error of record first. That being so, that being so, let the lower court record be called for.
That will not be so far my
So he refused to accept the notice, then the notice was fixed on the door of the.
It was published in the newspaper then.
They after
So
published
that is
in
not the
newspaper.
refusal.
It's not that he has
You are
refused
not
to accept the notice, then it was
Then
fixed on the door of the.
notice should go to the
house.
respondent 2 and 3. But they are also the
They after
parties.
published.
Issue notice to respondent number. You
Three
were the
and
contesting
four. Three and
respondent.
Yes.
You were the main contesting
Yes,
respondent.
Main
1 and 2.
Respondent number 1 and 2.
The 3 and 4 is supporting.
3 and 4 supporting.
Supported.
So how does it matter? The will is only
Yes,
name of all
between us.
No. Since the contesting parties have already appeared, it is not necessary to
Yes.
issue notice to the other non-contesting respondents.
Obliged.
Yes, next.
Hearing under order 41 rule 11 of PDC, serial number 36, second appeal 24 of 22, Mr. Vishal Kumar Tiwari.
Lordship, third possible in Lordship.
Caveats.
It was mentioned, Lordship.
The later position has been issued.
No, Lordship. The rate of delivery position is going to be issued, Lordship. The next date, Lordship, is on 13th, Lordship.
It's going to be issued when?
Lordship. Lordship, the next date it will be issued, Lordship.
When? When was the
13th.
next date?
13th.
13th of?
In this month, Lordship. Therefore, Lordship, I was constrained to mention during the vacation, Lordship.
13th of this month.
Lordship. Next Monday, Lordship.
Next Monday.
Lordship.
We will hear it. Be ready on 9th.
Lordship, I am outside on 8th to 9th. Lordship, can be
9th.
9th, 7th. Lordship, 9th.
Under order 41. Is there a revision suit?
Admission.
Affaired by both the courts.
Affirmative.
What is your ground?
Ground lordship is that the main lordship I was harping upon two Supreme Court judges. Since lordship the matter was argued before the court below, and it was properly asserted before the court below that there are specific direction by the Honorable Supreme Court that if some advance has been taken, though it is against Section 3 of the Act lordship, that has to be seen whether that fulfills the area of the rent or not. If that fulfills the area of the rent, then lordship there is no ground for eviction. That is my short point, lordship, that I'll give.
The eviction decree is only on the ground of default.
That was the only ground taken.
Not personal necessity.
No, because he has several. He has also not filed the petition for contempt.
We'll see to it. Thursday.
Thursday.
Order 41 will be.
Okay.
Next, press to duty.